This special session, which we squeezed in with lunch, is for civil liberties. The day 9/11 happened, they rounded up thousands of Muslim Americans because they were Muslim Americans or Arab peoples. Not because there were any charges, any proof, any affidavits. They rounded it up because of their race. That is a first-class denial of civil liberties. The so-called criminal justice system, in quotes, has 3 million people, majority black and Latino, in its jails. The highest percentage and number of people in jails in the world. The criminal justice system in the case of Mumia Abu-Jamal has kept an innocent man on death row for 28 years. He's accused of killing Daniel Faulkner, a Philadelphia police officer, despite the fact that 5 witnesses saw the shooters run away. We filed a 28-point brief in the federal district court when we lost the state courts because Justice Albert Sabo, who was Mumia's court judge and who had sentenced more people, majority black, to death row than any judge in the United States, denied over 100 motions made by the defense. And when we got to the federal district court, Judge William H. Yon threw out, roughly speaking, 27 of the 28 points in our brief, citing the reactionary Anti-Civil Liberties AEDPA, Anti-Terrorism and Effective Death Penalty Act. And that's an act that changed the history of American jurisprudence and now says that the findings of state courts must be given the presumption of correctness in capital cases, as opposed to the courts are allowed to consider all of the evidence of innocence and challenge the findings, especially in Mumia's case. The reason they put in the AEDPA is because prior to it, it was designed for Mumia Abu-Jamal. A full 40% of all state court convictions in murder cases were reversed on appeal. Why? Because of incompetent counsel, intimidation of witnesses, police corruption, police planting of evidence. This is the result of a massive survey that got that 40%. Today we have the highest percentage and largest number of people on death row in the world. Again, overwhelming, 3,500 people and growing, overwhelmingly black and Latino. The rich don't go to jail. They go to luxury penitentiaries if they steal. There's a certain criteria that they have. If they steal, I think it's $50 billion or more, like Madoff. Anything less than that is considered traditional business. In the case of Mumia Abu-Jamal, they have cited every reactionary attack on civil liberties, including one that the Supreme Court ruled on that has resulted in the execution of people that, listen to this, I know you're not too bright today, but what it says is, innocence is no defense. Raise your hand if you understand that Supreme Court decision. Innocence is no defense. It's trumped by timeliness. Unless you can present the evidence within the time that the state legislature has determined, 3 months, 6 months, and so on, even if you can absolutely prove, as Troy Davis did, that he had nothing to do with the murder, you are considered guilty, even though you are innocent. Mumia Abu-Jamal is perhaps the world's most well-known political prisoner. The Supreme Court reversed a few months ago a decision that stood for 20 years in the Mills case regarding jury instructions, and therefore for the first time overturned a decision of the Court of Appeals that allows them to send back Mumia's case to the same court that rejected on the Mills case and reconsider whether to execute Mumia Abu-Jamal. This is the famous Mills case, which says that the jury instructions of Judge Sabo and all other judges was incorrect when they said to the jury, if you're going to find mitigating circumstances to sentence Mumia to anything less than execution, like life imprisonment without parole, you have to be unanimous with regard to every mitigating circumstance. And that's what Judge Sabo told the jury. That meant that one single juror, if 11 jurors says, well, there's one mitigating circumstance, the policeman took a gun and shot Mumia 4 times, and when he was on the ground, he hit Faulkner with his hand, and Faulkner had a heart attack and died. I'm sorry, that's not a mitigating circumstance. This is hypothetical, but that's exactly what happened in Mumia's case. So the Supreme Court, using a Smith versus Spisak case, Spisak was a Nazi bigot who killed 3 people, walked into the courtroom with a Hitler mustache, said he would kill the 3 people again, but he didn't get the proper instructions. So the Supreme Court, in all its majesty, reversed 20 years of law in order to get to Mumia, and the Pennsylvania court, this is an Ohio case in Spisak, the brief was filed, an amicus brief by Pennsylvania and other states who want to kill blacks legally, in quotes. So Mumia's life is up for grabs. We cannot build a mass, and by the way, I should say that the reason I'm speaking a little longer is because Pam Africa, who is the head of the International Concerned Family and Friends of Mumia, and Suzanne Ross, who had an emergency physical problem, could not be here, so I've been asked to take that 2.5 minutes, and I'll wrap up very quickly. So Mumia is symbolic of the attack on civil liberties that runs across the movement. We can't build a movement for human rights, for human solidarity, and against war if we don't solidarize with the victims of the oppressed in this country and everywhere in the world. Our principle is the same as the ILW's. An injury to one is an injury to all. If we are going to build a movement that includes the Palestinians and Arabs and Muslim peoples who go to jail regularly because of their race, we have to build an inclusive movement, a movement that defends every victim, not only the millions that are murdered abroad, and there are millions in Iraq and Afghanistan, and of course 4 million in Vietnam, but the millions who are slaughtered and denied their democratic rights in this country.